So this, just so you know how fortunate Bannister is compared to all the rest of you, is that I have an IRS Christmas tree ornament that I received. I started with the IRS in 1993, and that was the 80th anniversary of our beloved agency that treats us so well. And so I had found this recently. Notice that it says many happy returns, 1913 to 1993. But that's not all, because let's see, I forget which page it was. Let's see if I got the right one.
While you're looking for that, could I interpret that happy returns doesn't mean you returns, meaning many happy returns from taxpayers?
Yeah, like many happy tax returns, right? People are so happy when they file them. But okay, yeah, here's the page that I thought, especially Larry, but everybody that studies this issue will get a kick out of. So this is a little brochure that was in the package with the ornament. And so notice how what it says here in the third paragraph. This is about the 16th Amendment, okay? By passing the amendment, Congress was able to bypass the pesky limitation of Article 1, Section 9 of the Constitution, which required that all taxes be uniform throughout the United States, and that, quote, taxes must be in direct proportion to the census or enumeration, unquote. So I figured that would light a stick of dynamite with Larry, especially, but I'm sure Mark too, and anyone else that studied this issue. So any comment, Larry or Mark, relating to Joe's little show and tell?
Wait, hold up. Don't
Want that back?
leave that on. Leave that on. Yeah, put that back. Yeah. Yeah. Let me get rid of this obnoxious dog. Yeah, see right there, that's a misrepresentation. We're not talking about uniform, we're talking about direct taxation, right?
Well, they actually they mention both, right? I mean, they basically refer to the two, the uniformity and the proportionality. But number one,
the pesky that all taxes be uniform throughout the United States. What's pesky about that?
Yeah, and they basically bypassed both limitations, right? And they're pesky. These pesky limitations, like the Constitution, right? Anyway,
That's a double speak right there, just like in your many happy returns.
Yes. So just wanted to give you a little indication of the kind of propaganda. I don't even know if those ornaments were available to the public or not. I just unmuted you, Larry.
Thank you.
Is smoke coming out of your ears, Larry? Do you have any comments?
Yeah. You're talking about I saw this years ago too, about them offering this ornament during Christmas.
Oh, and you didn't get one or 10?
No, I didn't get one.
Well, I still have mine, and it's the gift that keeps on giving, especially with this the insert, the little pamphlet that came with it. Anyway, enough of my show and tell, but I thought you would get a kick out of that. There's other pages, maybe I'll share them another time, relating to 1040s and all kinds of fun. So anyway, we shall get to more serious matters. And so being that Larry is here, did you find your dog, Larry?
Fortunately, yes.
That's good. All right, well then I've got everything ready for you. I've got the 3 PDFs. Attorney Larry Becraft generally gives presentations here at the show, and always excellent presentations. And Mark always has some great perspective also. So Larry, you want to take it away? And can I have anything in particular on the screen for sharing?
No, not yet. Let me just get off into it.
Okay.
If you just study the current 1986 Internal Revenue Code, as most of the people involved in the tax movement have done for years, you study the filing requirements, and the filing requirements are centered around 6001, 6011, 6012 of the Internal Revenue Code. Well, when you read Section 6001, you find out that the people that are required to file returns, make returns, are those that are liable for a tax. Under Section 6011, you read that, those that are required to file returns are those who are liable for a tax. Now, where does it all begin? This is one of the things that we've been leading up to for several of the last meetings that we've had. Now Joe has Section 6001 on the screen. It says every person is liable for any taxes imposed by this title. Those are the ones that are persons liable are required to file returns. Shall keep such regular returns, such statements, make such returns, comply with such rules and regulations as the Secretary may from time to time prescribe. So being liable for a tax is real important. And I'm sure most of the people that are interested in these tax issues are at least familiar with these two code sections. Now, the question I would like to pose to people that are interested in these issues is, well, when did this all begin? Now, everybody involved in the tax movement is familiar with the fact that in 1913, Flannery Knox claimed on Joe's birthday that the 16th Amendment had been ratified, the 16th Amendment forming the foundation for the income tax. Well, we've been getting into in these prior meetings, when all these laws began to appear on the books. And is there a possibility that if we study the old tax acts, then, there's probably a lesson to be learned, or at least there is a way for you to better understand the tax laws. So one of the things that, we've been talking about in the prior meetings, I talked about the 1913 Income Tax Acts, the 1916, 1917, 1918, 21, 24, 26, 28, 32, 34, 36, 38, and then the codification of all the tax laws in the 1939 Internal Revenue Code. And then the 1939 Internal Revenue Code was rearranged in August of 1954, and Congress created the Internal Revenue Code in 1954. And then in 1986, they came along and said, well, we're just going to rename the 1954 code to the 1986 code. And I have, during these prior Zoom meetings that we've had, implored upon people, it's essential for you to understand, because there is a lesson to be learned about the prior tax acts. And it's not difficult for people to become familiar with at least the basic pattern of the tax laws, more so than people inside the Internal Revenue Service. I mentioned in the past, that when I've defended people in charge of tax crimes, I have an IRS special agent or a revenue agent on the stand, and they inquire about their knowledge about the tax laws. Well, what do they study? And it's always just manuals of the IRS. They don't even really get into the historical foundation. So I have made the suggestion to the participants in these Zoom meetings that perhaps, and it's not difficult, perhaps if you got a working knowledge of the prior tax acts, it might be beneficial to you. Now, one of the things I've laid out in the past is something that we're going to be covering tonight. Over a couple of days ago, Mark and I got together and we came up with a real good presentation. So, Mark, would you mind bringing up, I don't know whether Joe's got it or Mark's got it, but that document that we create, yes, there it's on the screen. Okay, very good. Bring it up, Joe. Is that as big as you can expand it to? Yeah, that would be better. Now, one of the things we've talked about in the prior meetings, this Zoom meeting, the 16th Amendment was ratified in 1913, allegedly. And then in October 1913, Congress comes out with a Revenue Act, which it was a but there's two types of taxes that were in the Revenue Act of 1913, tariff, and then the Internal Revenue Code, the Internal Revenue Laws. So we've discussed that. Now, most people are unaware of the fact that in 1916, Congress comes along after the Brushaber case comes out and repeals the 1913 Act. Now that's kind of odd, because if you're a student of the tax laws of the United States as set forth in the statutes at large, typically what Congress does, once they enact a new tax and get it tested in the courts, thereafter, if they're wanting to increase the tax, all they do is, come out with an amended version of that tax. But what a lot of people haven't known in the movement for a long time, I've talked about it as frequently as I've spoken to public crowds in the past. I've mentioned, this is one of my pet peeves. People need to know about this series of tax acts. And I think it was last week when we were talking about the 1916 Act, I said, well, the 1916 Act repealed the 1913 Act. And there seemed to me to be a hushed silence, that came up for the participants. What do you mean the 1913 Act was repealed? Most people believe that the 1916 Act didn't repeal the 1913 Act. Well, a couple of days ago when Mark and I were going through it, I was kind of astounded, that when we talked about it, it was kind of profound to Mark. So now can we go to the Revenue Act of 1916? Mark, do you have that handy?
Yes.
Okay.
I do, and so does Joe, and I was going to suggest he does a word search for repeal. So go Control Find. And this is a lesson for people that have the thumb drive already with a CD. And you do the same procedure we're doing here, guys. And you do that, and you're going to find the word repealed. And there are about 8, am I correct, Joe? 8 matches?
Yes,
If you look to the
matches.
right, eight matches, good. So you can click to those arrows.
Well, I think it's
left or
section
right.
24, which is at the bottom of the page.
Well, yeah, but I'm trying to show people how they can find these things. And these we highlighted for them. And look at that, jumps immediately to the repealed. And if you this is the most relevant section, section 24. And you can read that and explain that, Larry.
All right. Well, if you have access to, and this is one of the reasons why I encourage, decades ago, I produced a website that's really a flash drive, that you can stick all this on a flash drive and pull up one HTML file, and you can access. You don't have to go anywhere else. You don't have to do any hunting. All you need to do is pull up that HTML file, which explains it all. And it provides, citations to all of the tax acts as well as the regulations. So it's been my experience, and this is my bottom line position. I produced that flash drive, that website on disk, for the purpose of making it real easy for those who want know something about the tax laws to be able to pull them up and have a one click access to all of the old tax acts and all the old tax regulations. And they're word searchable. So that makes it very easy for a lot of people to do some research into the income tax laws. Now, I maintain, the courts kind of pretend, well, the laws are supposed to be understood by the average man on the street. Well, okay, if that's their position, then we're going to operate under that presumption. They should be understandable by the man on the street. Well, that's not necessarily the case, especially for something like the income tax. They're kind of complex, and for even lawyers, they're hard to understand. But we're going to look at them so that the man on the street can understand them. Now, one of the false assumptions of people in the tax movement have made for decades is the assumption that the tax imposed in the 1913 Act has been carried forward just by amendments. And my position been, no, you were unaware of the fact that the 1913 Act was repealed. And so here we're looking at on the screen the 1916 Act. And what does it say in Section 24? That's Section 2. Now, the 1913 Act had two big, broad sections. There was a tax act, a tariff, which were probably about 60 or 70 pages long, and that was Section 1 of the 1913 Act. Then Section 2 of the 1913 Act imposed an income tax. So what do we see here in Section 24 of the 1916 Act? Let me read it. Section 2 of the Act approved October 3rd, 1913, entitled An Act to Reduce Tariff Duties and to Provide Revenue for the Government and for Other Purposes, is hereby repealed. Couldn't be any plainer than that. Except as here otherwise provided, and except that it shall remain in force for the assessment and collection of all taxes which have accrued thereunder. Well, that makes sense. That's what they always do. If they're going to repeal it, for any taxes imposed by the act that's being repealed, they're going to continue to allow its collection of the taxes that have accrued under the act that is being repealed. And so that's what they're doing here. Now let's move on to the next page. This is something that's always been interesting to me, and I'm sure there's going to be a lot of people talking about this after tonight. But look at the 1916 Act, Section 25. Now, this is something that I think is real important. If you take a look at the tax imposed section of the 1894 Act, if you take a look at the tax imposed section of the 1913 Act, this is basically the format that those acts impose. That they impose the tax on from sources within and without the United States for resident aliens and citizens inside the country, as well as non-resident aliens and citizens residing abroad. So there were basically, in both of those acts, 4 types of people. And, the aliens were divided into those living in the United States and those who were non-residents. And the second class of people, citizens, there were those that were within the United States, as well as those that were outside the United States, living abroad. So those were the 4 classes of people that were subject to the tax. Now, in 1916, they come along and this way that they had imposed the tax in the past was no longer the way that it was going to be done. They didn't set forth these categories in the tax imposed section. They just mentioned aliens and citizens. And it was later provisions of those tax acts that dealt with non-resident aliens and foreign corporations, both domestic and foreign, and citizens at home and citizens abroad. But that no longer is the case in the 1916 Act. But here's what's real important. In this additional section relating to the repeal. Let me read it. That income on which has been assessed the tax imposed by Section 2 of the Act entitled An Act to Reduce Tariffs and to Provide Revenue for the government and for other purposes, approved October 3rd, 1916, shall not be considered as income within the meaning of this title. Now, that to me is real important. And for my study of the tax laws, for me, the way I construe this is that it shall not be considered as income from within the meaning of this title. It relates to the shifting around as to who they're subjecting to the tax. And if you really study the tax laws, it appears to me, that what is being the statutory scheme that's being imposed by the 1916 Act and which remains in effect by the subsequent acts is citizens are no longer being considered. And that, of course, there's going to be other people that are going to come along and they'll say, well, I disagree with that. But, I think it's something that's real important for people to consider, Section 25. Now, let's move on to the 1918 Act.
Larry, can I
Yeah, sure.
interject here?
Go ahead.
There will be sections that we're going to post here that are going to show citizens or residents. So would it be all right if I qualify now for the people on this call that the citizens, for the meaning of this interpretation, would be, let's say, citizens throughout the states of the Union? Would that be helpful?
Yeah, for sure. That's the way, when I think about these tax acts, to me, a citizen is the citizens in the states. Those
There we
are
go.
the citizens. Now, one of the things that I think is real important, you know, in the couple of decades right before the income tax acts were adopted in 1913, you know, we had some real important United States Supreme Court decisions. And at that time, you know, during the late 1800s, Uncle Sam was going around and taking control of insular possessions. And insular possessions are like, you know, Puerto Rico, the Philippines, Hawaii. And the Supreme Court was required in two real important cases to make a determination as to, well, what's the relationship between the United States and these insular possessions. And in essence, in those two Supreme Court cases, one dealing with Hawaii and then Puerto Rico, what the Supreme Court said is that the United States Constitution does not apply and govern in the insular possessions. And, you know, these cases dealt with, well, gee, if the Constitution doesn't apply to taxation in the insular possessions, you know, what kind of relationship does the United States have with the insular possessions? And so the Supreme Court said, well, hey, the taxing provisions of the Constitution do not apply to Uncle Sam's taxing authority in the insular possessions. And in fact, the insular possessions, since they're not a part of the Constitution, Uncle Sam governs them without restraint of constitutional provisions. So that, to me, this provision is really directed toward, is one of those features of the income tax that lead me to the conclusion that, hey, you know, this has a direct relationship to, you know, taxing in the insular possessions. You know, the citizens that are, in reference to the income tax, when you're considering the federal income tax, there's basically two types of citizens. They're the citizens that are in the United States, and they're the citizens outside the United States, and then they're the citizens in insular possessions. And in the insular possessions, Uncle Sam can tax in whatever way it wants without regard to constitutional restraints. Does that make sense, Mark?
Yes, it does. However, we got a quick call here to clarify whether you mean citizens within the 50 states, because that we cannot make an assumption of what you mean. So I think you've already kind of answered that, distinguishing between citizens within the states, citizens or residents within the states of the Union, as being under a different jurisdiction from citizen or residents within the territories under federal jurisdiction. Is that correct?
That is correct.
Okay, I hope that answered the J specifically.
Because you know the Constitution only applies in the states, and the restraints upon Uncle Sam in the states are not applicable to him in the territories and insular possessions. And so, you know, the question that you got to reach conclusion about is, you know, well, then how much of the Internal Revenue Code addresses these citizens in these two different places? And, you know, it's a very strong case can be made, you know, that the citizens that are really subject to the Internal Revenue Code are the ones that, well, you know, when you get into the 1918, 1921, 24, 26, 28, you know, you start looking at those parts of those tax acts, you know, there are very, you know, Congress comes along, very specifically deals with citizens in the insular possessions. Why is that? And there are very, very specific provisions that deal with the citizens in the possessions. And why is there not something as expressly clear in reference to citizens of the states? What's so difficult? And, I think one of the things we're going to be talking about during the course of this presentation tonight is that topic, the topic we're going to discuss tonight, will help you. It will give you a foundation so that you can then start dealing, when you start studying the income tax laws, these old ones, now you can begin to see, gee, there's something here. There's a division, in reference to citizens. What's so odd about this? Well, why are they talking about specifically the citizens and the insular possessions? And, that's the way it is today. There's, you get over, when you deal with the source rules are 861, 862 of the Internal Revenue Code. Boy, they're very specific about the citizens and the insular possessions. Well, if the citizens and the insular possessions are really, subject to different rules of taxation, where's the express taxing of the citizens in the states? That is a very interesting question. So, hey, Mark, let's go on. Let's move on to the other tax acts. This is what I want people to understand tonight. We're going to go up to the 1939 Internal Revenue Code. The 1939 Internal Revenue Code was.
Oh, wait. Before you go there, there's 1918. Okay. There's 1918 we have to
I want to explain. Would you want to comment more? You want to discuss more about Section 25?
I was talking about the 1918 comes next in our sequence.
Yeah, well, okay. Yeah, I was just restating. I'm not moving over those. I'm getting ready to get into.
Got it. Okay. Thanks.
The 1939 code was nothing more than the codification of the existing tax laws, including the income tax. And so the income tax from the 1938 Act went straight into the 39 code. Well, the 38 Act was a tax imposed in lieu of the 36 tax. You go back to the 36 tax, that was in lieu of the 34 tax. The 34 tax was in lieu of the 32 tax. The 32 tax was in lieu of the 28 tax. 28 was in lieu of 26. 26 was in lieu of 24. 24 was in lieu of 21. 21 was in lieu of the tax imposed by the Revenue Act of 1918, which replaced the 1916 Act as amended by the 1917 Act. So I moved in reverse in what I just stated. So now we're going to move forward and we're going to deal with these specific acts. And here in 1916, you can see that there's a tax imposed, repealing of the 1913 Act, and now they got a new tax imposed. And you have this real odd section, Section 25, which will be subject to, a lot of people will come up with their own conclusions. So, Joe, let's move on to, Mark, let's move on to the, yes.
There was one more section, Section 902 at the end of 1916 that we talked about. And if you click on the next, see and what it says repealed, click on the next one. Click on the next one. Click again. Click again. Click again. Again, all the way to the last one until you see the highlights in yellow. There you go. So this is the final say-so.
Yeah, this is the way they typically end any act of Congress. At the very end, they're going to tell you when
that's correct.
Takes effect.
I think that's important. Yeah.
Oh, okay. All right.
So that unless otherwise herein specially provided, this act shall take effect on the day following this passage, and all provisions of any act or acts inconsistent with the provisions of this act are hereby repealed.
So at this stage, you had the tax imposed by the 1916 Act. Now, we're not going to get into the 1917 Act. If you want to do that, you can get at the statutes at large. The disc that I provided starts in 1918. And the reason for that is because there's a format, a pattern to the tax acts between 1918 and 1926. Then in 1928, you have a second format. And I like to call this second format for the tax acts as, that's the format for the 39 code. So the same basic format existed from 1928 all the way up through August of 1954. Then in August of 1954, Congress comes along and enacts the Internal Revenue Code of 1954. And the Internal Revenue Code of 1954 remained in effect until 1986. And in 1986, all Congress did was, I guarantee you that there was some behind the scenes things that were done that for its own purposes, for its to keep it straight in its own mind, a major change was made, and that major change was made external to the statutes at large. It happened primarily in delegation orders, things of that nature, stuff that would appear in the Federal Register. So the system understands that there was a major change made in 1986. However, visually to us, nothing really changed. The 54 code, the pattern was there. All that happened in August of 86 was Congress changed the name of the 54 code to the 86 code, but behind the scenes, like in delegation orders and things of that nature, there were major changes that were being made. But for its own purposes, Treasury Department didn't want to bring it to light. But let's move on to the 1918 Act.
Before we do,
Okay, go ahead,
just a reminder, as we discussed, we wanted to point out to the people listening that the key discussion of the 1918 versus 1916 is because a lot of people, like a lot of people here follow Thomas Freed, Dave Champion, and others, and they're all basing their explanations starting with the 1913 Brushaber decision and Treasury decision 2313, and they make that the key point for their relevant explanation of how the income tax operates, where in fact, once we learn the 1913 has been repealed, 1916 becomes more relevant, and the most relevant incipient or starting point should be 1918, because this is what the courts would be compelled to listen to in a legal argument presented before the courts. Is that a correct statement, Larry?
Well, yeah, generally so. But, in 1916, it's different from the way things operated in the past, because other tax acts, once Congress had been to, once a statutory scheme has been to the Supreme Court said it's constitutional. Congress keeps that same scheme in effect. Well, the difference here with the income tax is that when the Brushaber case came out, Congress didn't do that. They repealed the 1913 Act and they imposed something new in 1916. And when you take a look at the 1913 Act and the 1916 Act, you can see, hey, these are two different schemes here. And it's obvious. And, that obviousness is one of the things that people need to know about. Because once they know that, hey, there was something that changed in 1916, and then they start taking a look at the tax acts, they can begin to see in their mind the scheme that was imposed by these tax acts. So let's move on to the 1918 Act.
There was one last contention that we were supposed to address, and that was the difference of opinions between who Brushaber was, whether or not he was a withholding agent for a foreign entity, or he was the non-resident alien expressed in Treasury Decision 2313.
Well, in reference to that, most people don't have the Supreme Court briefs. I do. And Mark, didn't I send them to you?
Yes, you did, and
Okay.
But those are not made available on the CD. So, do you want us to have a next presentation next Friday about the Brushaber specifics? Is that relevant? Do you think?
Well,
Or maybe
to
we should
me,
vote.
it really isn't. But I mean, because a lot of people have been exposed to differing opinions, it might be beneficial for people without any. To me, it's real important. It was important for me when for these questions, when they came up, decades ago, I used the briefs themselves to at least get things corrected in my own mind. And I think it would be beneficial for people to at least have access to these briefs because, there were a series of Supreme Court cases that were presented to the Supreme Court in 1915. And, it's by a series of these decisions, that's important. But a lot of people rely upon the Brushaber case and they come up with these different ideas. Oh, Brushaber was a non-resident alien or Brushaber was a withholding agent. No, Brushaber was merely a stockholder in the Union Pacific Railroad. And he sought to, they were collecting the tax from his dividends, and the Union Pacific Railroad was also paying the corporate tax. And so those were the main features of the Brushaber case. Those were those were at least two issues that the Supreme Court was addressing in the Brushaber case. So for people to come along and say, oh, Brushaber was a withholding agent or Brushaber was a non-resident alien or some other thing, by reading the briefs themselves, you learn more about the facts than the Supreme Court expressed in the Brushaber case. Does that make sense?
So we're gonna make a vote. I'm gonna make a vote with my group, for example, and see if they want to talk about Brushaber in the next Friday. If not, we'll move along and we go in a different direction.
Okay, hey Mark, it's 8:40, so let's spend at least 20 minutes getting through all the acts. And
Okay,
I think,
good.
to me, it's real important for people to at least appreciate, at least study enough of these tax acts so they can see, yeah, there is this connectedness. They are related. The 39 code just simply pulled the 38 Act up into its provisions. And, all these acts are connected because they're in lieu of. And
Right. We highlighted that in the 1918, right here, the one that Joe is showing.
Yeah. Well, let's, hey, Mark, what are the things last night when we were doing this shortened version, pull that up. And that's what I would like for people that are attending this meeting to at least receive tonight.
Look into the extracts, Joe.
Yeah. Right.
There you go.
Okay. Now, here I've pulled out the relevant provisions, and after we discuss this tonight, then I guess this could be put in the chat. Can it, Joe?
I can make this available to my people, but there are some that are not my people, so they can, if you put it in the chat, they can download it or make it available somehow.
So you're saying
That's
this
not very
actual
long.
language, Larry, to put in the chat?
This document.
Oh, the
extracts.
document? I don't know. I'll look and see while you're describing it. See if I can
Okay.
do that.
Well, this just kind of summarizes, provided in a summary fashion, the point that I want to make about the interrelated, the connectedness of all the tax acts. Here you have the Revenue Act of 1918. And in Section 210, you can see, in lieu of the taxes imposed by Section 1 of the Revenue Act of 1916. And so here you have the tax imposed by means of the Revenue Act of 1918. Move down the page.
So, Larry, real quick, what does that section B there says? Right there before you move along, it says that in case of citizens or residents of the United States, the rate of $4,000. People reading this for the first time, they would think that, oh, the citizens of the United States in the states of the Union. Is that correct?
Well, this is what I say happened between 1913 and 1916. The Congress is carving out, an express, obvious statement that certain sections apply to citizens at home, which was the way it had been in the past. But now what I find is that, this issue of citizens at home, a section of the tax act relating to a citizen at home, is now quietly avoided. And it's only in later provisions of the act does Congress get around to in the Tax Acts with being expressed which citizens where. So like, let's say you start taking a look at the Revenue Act of 1921. You see that there's a tax imposed. But, but this issue of, like with the 86 code, sources, the source rules, citizens where? And they are very express. The thing I like about the old tax acts is, they're a lot shorter, they're a lot easier to understand, and boy, once you start looking for it, gee, citizens where is very clear in the old tax act. They just come out and say it says in insular possessions. Well, why don't they say the same thing about citizens in the states? Why are citizens in the states avoided? So that's one of the points I want to make here. You see this tax imposed in Section 210 of the 1918 Act, and then in reference to who's liable for the tax, you get down into payment of the tax to the source, which is the withholding agent. And this is the point I want you to understand. As you go through these tax acts, locate the section that deals with somebody that's liable for the tax. There has never been in the 1921 Act, 24, 26, 28, 32, 34, 36, 38, 39 Code, 54 Code, 86 Code. No dealing with citizens at home. Why do you have all the way up to the 39 Code, when you're looking at the citizens, and those that are expressly treated are the citizens in insular possessions. And that's real clear all the way up through the 39 Code. Then when you get into the 54 Code, what the 54 Code is nothing more than a rearrangement of the provisions in the 1939 Internal Revenue Code. And the purpose, they want to make it a little bit more convoluted, and that it is. So when you take a look at once you start studying these old tax acts, where you're dealing with just one section with dealing with the citizens at home, boy, in the 54 Code, 86 Code, now they've made it a little bit more complicated. It's still citizens in the insular possessions they're talking about and citizens abroad, but boy, now they have busted them up into a large number of sections. And the purpose of that is to make it a lot more complicated. But the purpose of this little document right here is to show that, as you go through these tax acts, like we're right here on the 1918 Act, they expressly impose a tax on citizens and residents, and the parties that are liable for the tax are the ones that are being subjected to withholding. Well, who do they withhold from? And there are withholding provisions in all these tax acts. Payment of the tax to the source, like in this act here, the 1918 Act. All individuals, corporations, and partnerships in whatever capacity acting. Of non-resident aliens and foreign corporations. Going down.
This is what we discussed last time between
Right.
Who is liable and who is made liable. And I think Section 2021 describes the parties made liable. These are all individuals in whatever capacity having control receipt of wages, premiums, annuities, compensations, remunerations, periodical gains, profits, and income of any non-resident alien individuals. So those are parties made liable. And the parties liable are the actual non-resident aliens in certain circumstances and citizens and residents in the territories. Is that correct?
Well, those that are liable for the tax, let's read it. Section 221, that all individuals, corporations, partnerships, and whatever capacity acting, having control of the profits and income of any non-resident alien, is required to deduct and withhold such, equal to 8%. All of these withholding agents that are required to deduct and withhold are, move down the page, Joe, hereby made liable. So the withholding agents are made liable. And
By
And
withholding from party is liable for the tax.
yeah.
Got it. Thanks.
And the purpose of this chart is you just simply say, hey, it remains the same. This same scheme about the withholding agents making payments of income to non-resident aliens and foreign corporations, they are made liable. And remember, being liable is real important under Section 6001, 6011 of the Internal Revenue Code. The people that are required to file returns are those that are liable for their income tax. And tracing back this issue or this subject, this scheme of being liable, it shows up in all the old tax acts. So it's real important that I think for people to understand, first this feature of, in lieu of, the Congress coming along and virtually every 2 years, revising the income tax, making them all interrelated in essence, and then being liable for the income tax is something that's very obvious when you get around to looking at the old tax acts. Let's move on. I've got almost the end of the hour. Revenue Act of 1921 is the same way. Section 210. In lieu of the tax imposed by Section 210 of the Revenue Act of 1918, there's to be levied this tax. Okay, let's move down the page. Next section, Joe. Payment of the individual tax at the source. Again, this is relating to the withholding agents. And all individuals, corporations, and partnerships in whatever capacity acting, having control of the rents, salaries, wages, blah, 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 gains, profits, and income of any non-resident alien or a foreign partnership, they're required to deduct and withhold. So this is the withholding agent that's being subject to the discussion in Section 221. And in subparagraph C, every individual, corporation, or partnership required to deduct and withhold is hereby made liable. So here you have this liable provision relating to the withholding agents. And the same thing happened. This is the way it is all the way through the 1939 Internal Revenue Code. Revenue Act of 1924 is the same scheme. Section 210 imposed the tax. Section 221 deals with withholding agents.
Is there any meaning behind that excess amount, Larry?
No, I don't consider it. No. Mm-mm.
No. Okay.
Section 221 deals with withholding agents. Same thing. And the withholding agent, so paragraph C in all these sections is liable, made liable for the tax. Now, are we in 1926? Here's 1920, same thing. Now, the other thing that happened, all these the 1918, 21, 24, 26, 20, those acts, they were all basically the same pattern. And we're getting ready to move into the next new pattern. And now you're beginning to see some of the things, these little changes, that are interesting. But here the Revenue Act of 1926 there's nothing different. They imposed the tax here in Section 210, Section 221, the withholding agents of non-resident aliens, foreign corporations, they're made liable for the tax. Now here's where we get something very interesting. I told you that there are three basic patterns, schemes. You have the Tax Act scheme that was in effect between 1918 and 1926. That's the first one. The second one is what I call the pattern for the 39 Code. It starts in 1928 and goes all the way up through August of 1954. And then in 1954, what Congress did was reshuffle the 39 Code, the way it looked in August of 1954, throws it out like they cut up all the sections of the 39 Code and even cut up a bunch of the sections into subsections. And then they scattered them across the floor, and then they sweep them up and stack them all together. That's the 54 Code. So a lot of people don't really understand, what happened with the 54 Code, how it was created. they don't understand that, well, it was based upon miscellaneous provisions of the 39 code. And a lot of people don't understand the 1939 code. But here's what changed. Remember, in the first scheme that was in effect from 18 through 26, in the very section that imposed the tax, they said in lieu of. Well, one of the things that happened in 1928, Congress carved out the section that talked about being in lieu of. So now the tax was imposed in section 211, just like in the previous acts. Except in the previous acts, the section that imposed the tax mentioned that it was in lieu of. Now Congress carves it out in the lieu of feature and sticks it over into section 63. And so the taxes imposed by this title shall be in lieu of the corresponding taxes imposed by the Revenue Act of 26. Now, here's one of the reasons why I think that they did this. You know, it's been very beneficial for Congress, and I'm sure they experienced this with other tax acts. You know, for them to make things look in lieu of, and then over time just kind of separate, out of the public consciousness, that there's a history behind all this, and people just, I can see people say, like in 1932, 1934, new people coming along and being confronted with the issue of do I file a tax return, income tax return, and a lot of people would be educated about the federal income tax, and so they would just look at simple little provisions, and people wouldn't realize or understand, that, hey, there's a history behind all this, and it's that history that is very, very educational. So starting in 1928, they carve out from the tax imposed section the in lieu of feature, and now it's stuck over in section 63. Now, okay, Dale writes, you read a lot of court cases, you can see decisions that are corrupt. Well, that goes without saying. So now in section 144 of the 28 Act, now you're dealing with the same thing about withholding. It's still non-resident aliens are subjected to, non-resident aliens and foreign corporations, they're subjected to withholding at the source. And in subdivision C, it's the withholding agent is made liable for the tax. Section 144. Now, in later years, Section 144 becomes Section 143. But here, this is just like the other ones. It's the non-resident alien that's made liable for the tax. And here in the Revenue Act of 1932, you have the tax imposed in Section 11, and then in Section 143, there's the tax imposed in the 32 Act. Section 63 is the in lieu of feature, and then in Section 143, you have the same old scheme regarding withholding. Now, in the Revenue Act of 1934, we have the same thing. Section 11 imposed the tax. Section 63 mentioned, in the past we were talking about it being in lieu of. It's still in lieu of. And Section 143 deals with withholding. And it's the withholding agent that makes the withholding agents are liable for the income tax. So let's move on to, we're on 36, I think, or 34. Move on to the 36 tax. Yeah. So here in the Revenue Act of 1936, you got Section 11 imposes the tax. Section 63 mentions this in lieu of. And Section 143 deals with withholding, just like all the others. Let's move on to the 38 Act. Okay. Here you have in Section 11, the tax imposed. Section 63 mentions this in lieu of. And Section 143 deals with withholding. and its withholding is only on non-resident aliens and foreign corporations. Now, here is what is real important. How was the 39 code created? Joe, if you could move down to that. Do I have any questions up to this point before we get into the 39 code?
Yes, there are questions.
All right,
yeah,
go
there
ahead.
are questions, and it's a perfect time to break a little bit for questions. We have the latest one is Tapster. Is a foreigner that has legally immigrated a federal jurisdiction and is working in one of the 50 states, a non-resident alien individual. And that's a good question because people in the filing 1040 NR state of mind are thinking that the definition of United States makes them non-resident aliens for purposes of the Internal Revenue Code. So if you could address that before we jump to the 1939, I think a lot of people would appreciate it.
Well, I don't think we're a non-resident aliens.
Not yet.
In reference to non-resident aliens, over time, it became important for them to make a distinction between non-resident aliens and resident aliens. And so you provide, back in 7701, you have these definitions about non-resident aliens and foreign corporations. And now we have these rules about how long you got, depending upon your stay here in the United States, whether you are a non-resident alien that's subject to withholding or a resident alien. And that's a real important distinction, because when one is a non-resident alien is only subjected to tax from sources within the United States. A resident alien is subject to, I maintain, when he's abroad, he's subject to withholding on his sources of income from within the United States.
I believe they call that the physical presence test, where you have to determine how many days that the non-resident alien has been in the U.S., at which point, if they reach a certain number of days, then they would become a resident alien or be treated as a resident alien versus non-resident. So look up physical presence test. I'll try to look that up while you guys are talking.
Larry has a jurisdiction memorandum, 1999, that he posted on his site. You guys go there, and it's an extremely well written about territorial jurisdiction and very well justified with all case.
Are you talking about the government report?
Government report and federal jurisdiction that last updated 1999. So the subsequent very important question in the group before we move to 1939 was addressed regarding Cook v. Tait, where this American guy was living in Mexico, yet the court said that no, you got to pay.
Well, hey, it's one of the few cases decided by the Supreme Court dealing with the taxability of a U.S. citizen. And so the Supreme Court, they had cases dealing with Mexico. This guy was living down in Mexico, didn't file a return. And that issue went up to the Supreme Court. Supreme Court said, yes, we can tax a citizen living abroad.
But that was not a territorial jurisdiction, was it?
No, it wasn't. That's Mexico. So, the
what kind of jurisdiction was it?
Well, for a citizen abroad, one that comes back into the United States, Uncle Sam's got jurisdiction over him. Think about it. If you're coming in from abroad, you're going to need to get past these employees of the United States that can physically restrain you from entering the United States. That's real jurisdiction. And so the Supreme Court holds, and there's a reference to other cases, about citizens of the United States being tried abroad, in our American courts abroad. There's a lot of instances in which Uncle Sam exercises jurisdiction over citizens abroad. And one of the reasons why Uncle Sam can't exercise jurisdiction over a citizen abroad is through this issue of coming back into the country. Now, I give you a real good illustration. In the tax movement, there have been people that have gotten word that they're getting ready to be indicted, and so they fled the country. And, of course, Uncle Sam says, well, we can tax citizens abroad. Well, those that permanently, American citizens that go abroad and never come back into the United States, Uncle Sam has no way to do anything about them.
That was not Cook, right?
What?
That was not Cook in the Cook v. Tait case.
No. Of which case are you talking about?
Cook v. Tait or Tait.
Well, yeah, that's the Mexico case.
That is correct. So if we can make a special Zoom call about this for people that want to discuss particular cases. Right now, we're addressing the principles of the matter. So let's put this in the background for future sessions. Is that all right with everybody? So we can move on to the 1939 code.
Let's move on. We are going to move on.
Good, great. All right.
So, what Uncle Sam, the point I was making is I know of people that have American citizens that left the United States and have never come back. And Uncle Sam can't do anything about them being required to file returns. The only way that they could have any control over that was if the citizen wants to come back into the country. At that point, Uncle Sam has some real jurisdiction over that person. However, if the citizen abroad, severs all connection with the United States, how can Uncle Sam do anything to him? So the real jurisdiction consists of for a citizen abroad when they come back into the United States. But hey, let's move on to, we've been at this an hour. Let's deal with the 39 code. The 39 code, in 1939, well, let me back up. In 1926, in 1872, Congress created the revised statutes of the United States. At that time, a number of states had created codes for their laws. And a code like Alabama code or Georgia code or Tennessee code or Nevada code or California code. A code is just sticking in one title all laws regarding a related matter. All the criminal laws, typically in a code, are stuck into one title. All the tax laws are stuck into one title. Court procedures are all stuck in, they're passed, it all over many, many, many years. But a code just simply, in reference to a particular subject, sticks all the laws of a jurisdiction in one title. We call them titles. So in 1939, there were federal tax laws scattered everywhere throughout the United States, statutes at large. You had booze tax, you had tax on tires, you had taxes on gasoline, taxes on anything and everything. Rubber, iron, just countless subjects, admissions and dues. Those taxes were scattered everywhere. So what in 1939 Congress was attempting to do was to take all these laws, whenever you were referring to them in the past, you'd refer to the act of such and such of 1927 or, an act of such and such of 1932. All you do is you stick all the laws into one spot. So in 1939, all Congress did is, they'd studied it for a number of years. And in fact, they had created in 1926 the United States Code. In Title 26 back then was the tax laws. And so in 1939, Congress wants to create one book that is enacted into law that contained all of the tax laws. So that's what they did in 1939. So where did the income tax come from? Well, in 1939, the income tax was, in essence, found in the 1938 Act. So they pulled and stuck into the 39 Code in reference to the income tax. They took it from the 1938 Act. So it's the 1938 Act that went into the Internal Revenue Code of 1939. So let's go down to the 39 Code, Joe. But there are some very unique little things you need to know about. You go the other way, Joe. Go down. 39 Code. So, in 1938, it was Section 11 that imposed the tax. And Section 143 dealt with withholding, as we've talked about. But, back before we were mentioning that this section, in the 38 Act, we had this Section 63, which talked about the in lieu of provisions. And so here in the 39 Code, that same section, Section 62, is something different. It wasn't it's different. So there is that section in the 1938 Act.
Well, that's Section 62, not 63.
Yeah.
We need to check Section 63.
Well, I think that may be Section 63, and the Section 62 is wrong. You want
to check it?
Yeah, check it out.
I'll check it, and I'll get back to you in a second. Okay.
But this is real important. I think it's real. If you want to try to begin to get a grasp of what's happening with the income tax, I think it's real important for you to know this scheme right here that we're talking about. The current code, the 1986 code, is the renamed 54 code. The 1954 code was nothing more than a reshuffling of the provisions of the 39 code. The 39 code was the codification of the existing tax laws, which included the income tax. And if you get that flash drive, you can, we've been only talking about the income tax. We're not concerned about the tire tax. We're not concerned about the gas tax, anything else. But there are other taxes. And so if you get the 39 code, you can see that there are other taxes. We're not talking about the other taxes, but it shows what the 39 code was. It was the codification, pulling all the tax laws regarding a wide variety of matters all into one act. And it was a big, thick book. And a lot of people don't have access to that. Well, with that flash drive, you will get access to that. And so you can pull up, while you're dealing with specifically under the old acts, like the 38 Act, 36 tax, 34, 32, 28, 30, 26, 24, 21, 19, 18, those are only the income taxes. On that disk, you'll have access to the 39 code, and there you can see all these other taxes. And so we're not trying to say that there's only the income tax that brings in the revenue for the federal government, but we're only focusing in on the income tax. And there are other taxes. Just like if you have the current code, you can see that there are other taxes, gasoline and stuff like that, booze. And the same thing happened back in the 39 code. Hey, they were taxes on admissions and dues. If you were going to go to a movie theater, which was hot back in, say, like the 30s, there was a federal tax you paid. But we are talking about the income tax. And so the 38 Act went into the 39 code. We have this change here about what is being looked up right now. Section 63.
I found it.
I think it is Section 63.
Yeah, I found Section 63. It says publication of statistics. It's not 62. So section
yeah, yeah.
63.
Oh, yeah.
It says the commissioner, with the approval of the secretary, shall prepare and publish annually statistics reasonably available with respect to the operation of the income, war profits, and excess profits tax law, including classifications of taxpayers and of income, the amounts allowed as deductions, exemptions, and credits, and any other facts deemed pertinent and valuable. Nothing having to do with what previous section 63 would say.
The in lieu of feature.
In lieu of feature, right.
And the section 62 should be the section 60.
Its rules and regulations is the same. That is correct.
But you can plainly see section 143 of the 39 code comes from the 38 Act. So here's the point that is real important for people to make, to understand. And this is the purpose of tonight's meeting. This scheme. And it's far easier to understand. You know, if you want to chart out, draw a schematic of how the income tax operates, it's a lot easier to do under the old tax acts. And the old tax acts were a whole lot easier to understand. True, they can be convoluted. So we're dealing with an agency of government that is very adept at writing tax laws and making them complicated, and making it so complicated that, hey, they can make you think, one thing when something else is really meant. So the point I want to make is this. The 39 code, this is something you need to get in your mind. Really it was withholding. And remember, they had withholding back in those days. And it only applied to non-resident aliens and foreign corporations. And so I've got this very interesting question. And this is something that people need to be concerned about. How do we...
This is a time where they need to raise their hands so we can have the question answer session before it gets too late.
Well, I don't know if it's already too late, Larry. How much longer?
Well, I mean, I was keeping watch of the time. It's now 15 after.
Yeah, I mean, typically we only go about an hour and 15.
Yeah.
So I don't know that.
Hey, we can start off with this next week.
Yeah, I mean, I think
what we covered tonight is a real good foundation. People need to know this foundation.
Yeah, so let me go ahead and go through the housekeeping.
Real quick, Tapster has a question, I think, or Yan has a question. Real quick, at least one tonight. Thanks.
Okay, let me get Tapster unmuted. Hang on, Tapster.
Right. Yeah, well, that's what I was raised my hand for earlier, Joe. Section 63 is your statistics. That's where it changed publication of statistics. But the point I wanted to make, Section 63 of the 38 code still applies because the 39 code did not change that.
That's an issue.
Everybody agrees with that,
solid
right?
Position. That is certainly a solid position.
Okay. I just wanted to make sure that I had that right. Okay.
Thanks, Tapster. And who else, Mark?
Was Jan says, so what about the alien part? But he is replying in the chat as what he meant by that. I asked him to raise his hand so he can have a direct reply. I don't know if he knows how to operate the Zoom to raise his hand, but we can address it. I don't know what he means by it. So what about the alien part? The question is incomplete. So for whoever wants to ask questions, give us some clues so we can properly address them.
Well, why don't he write it down and then ask it next week?
I'll do that, or he can contact me. He's one of my groups, so he can contact me and I will address him directly. If I need any support from you, I'll call you.
Fantastic. All right. Well, let me go through the housekeeping. And Mark, thank you for really, making this. I suppose you did you're working with Larry, did the highlighting, and that was really excellent.
Great. We're getting better at this, all of us.
Yeah, for sure. All right, everybody. So this is primarily for the future viewers on video, but it's always good to review. For Larry's website, you go to a start page or search engine that you like. We avoid Google. and type in Becraft briefs into the search bar and scroll past the men's underwear to Becraft briefs here. And that will take you to the Dixieland Law Journal. All kinds of topics here, but in particular, the taxation topic is right here. And that will lead you to all of these topics, very, very much similar to what we discussed tonight and others. And my website is agentfortruth.com. And I would point you to, in particular, especially with what we talked about tonight as far as liability, notice that if you go to the homepage and you scroll down to what did Joe find, you'll see that there's basically what I call kind of the four pillars or the four legs to the stool in terms of the IRS manuals. You can actually see that in the IRS's own internal manuals, those manuals, at least back in the 90s, they corroborated a lot of what Larry talked about tonight that you see in the actual statutes. Is
that in your book? Is that in your book as well, Joe?
It's in the book, yep. And also, because I want to give people information, you can see it for free here, but I go into more detail in my book for sure. But anyway, so, I encourage you to read these four because you'll see a lot of corroboration and similarity to what Larry talked about tonight. As far as being liable for a tax, well, you'll agree with the Internal Revenue Service because the IRS tells you they're required by law to tell you that you must file a return or statement with us for any tax you are liable for. So anyway, agentfortruth.com, you can find a lot of good information there. I also encourage you to go to my blog section because I wrote a blog article on the 1040A scam, how the IRS has to literally lie to their own computer systems to create assessments against those that don't file a tax return. They did it to me personally. I showed transcripts and notices that I received in my own personal circumstances. So I encourage you to go there. My X account is at Joseph Bannister. Lots of great information there. And that's it for the housekeeping. Any last words, Mark?
No, just I think that Larry did a fantastic job, and I think we should also have a meeting with you, having the opportunity to express from your insider's position in the next Zoom call to corroborate everything that we're discovering together.
Yeah, I could go into more detail, but
yeah, absolutely.
There's plenty of homework for people to go visit Larry's website and my own. And, in future weeks, Mark, any other resources that you have on the internet yourself or of that others put out. We're here to make people aware, just like I was made aware. And that's the reason I don't work for the IRS anymore. I would have been retired at this point and probably bringing in 150 grand just to sit on my butt. So the information you received could really change your life. It certainly did mine. Anyway, so we're really grateful that you all joined us here tonight. God bless everyone. And Larry, any last words? No, he's already muted. Larry's ready to go to sleep. All right,
come back next week.